Contract risks and management of contract risks. Welcome to the Risk Management of Everything channel. On this channel, you will see videos on risk management and the application of risk management to diverse areas and sectors. If you are new here, make sure to subscribe to our channel and press the notification button so you can be notified when we upload new videos. Thank you. The video discusses contract risks and contract risk management. In this video, you will understand the meaning and elements of a valid contract, contract risks, classification of contract risks, challenges of contract risks and how to mitigate them, financial limitations of aggravated risks, contract risk management, transfer of contract risks, and contracts insurance policies. Now, let us start. The meaning and essential components of a valid contract. Contracts can be verbal or written and are used to create or expand the relationship between two or more parties. The contract agreement should highlight how each party will interact within a given set of circumstances. Valid and enforceable contracts must have the following essential components. 1. Consideration. Each party to the contract must be providing something of value to the other, such as a product, service, or payment. 2. Offer and acceptance. An offer made by one party, such as to provide a good or service, is accepted by the other, often for payment. 3. Intention to create legal relations. The parties to the contract must intend for the agreement to be legally binding, and if such intent is not the case, it should be stated in the contract documents. 4. Consistent with the law. The contract must not be against public policy or the law. This is to ensure that the contract is valid and enforceable by law. 5. Capacity to enter into a contract. The parties entering into the contract must be capable of making the contract and understanding what they are doing. While contracts can include any number of parties, the most common type of contract is between two parties, with one acting as the supplier, provider or lessor and the other party as the purchaser, buyer or lessee. Consequently, contracting parties should consider themselves the primary and financially responsible parties for contractually assumed risk unless otherwise transferred via a written agreement. Contract risks. Contract risks affect the operations, arrangements and outcomes of, and the participants in, a contract. Contract risk entails potential losses due to a buyer's inability to pay or failure to abide by the contract agreement. There may also be collateral damage for employees of affected businesses in business-to-business contracts. Poor contract management causes friction between teams, and a lack of velocity can harm a company's ability to close deals. Poor lifecycle management can result in important dates being missed, leading to expensive renewal costs. A key aim of contract management is to establish a record system to mitigate this risk. Classification of contract risks. There are several risks associated with commercial contracts. Risks associated with commercial contracts may be classified into 5 categories: financial, legal, security, brand, and operational risks. 1. Financial risks. Financial risks are contract risks associated with the loss of money regardless of whether it impacts the contracting party's top or bottom line. Several contract financial risks include credit, liquidity, asset-backed, revenue leakage and cost overruns, and equity risk. Financial risks may arise during contracts when third-party bankruptcy occurs, key renewal dates are missed, and contracts are auto-renewed without cost evaluation and analysis. From a contract management perspective, the financial risk may be caused by missing a key contract date, for example, securing a contract renewal date or violating the automatic rollover clause. Another example would be a contract termination or compensation associated with missed delivery dates, milestones, claims, or warranty problems. 2. Legal risks. Legal risks arise due to a breach of contract with legal accountability or litigation potential. There are several legal risks, including regulatory, compliance, and dispute risks. For instance, regulatory risks may arise during contracts when location legislation is ignored, parties are unprepared for changes in regulations, or documentation doesn't remain up to date. The legal risk could occur from missing contract obligations, compliance requirements, or other rules for contract management. It could also result from intellectual property infringement charges, improper or lack of using the suitable legal clauses, confidentiality disclosures, and other contract disputes. 3. Security risks. Security risks can be attached to some of the highest profile and most severe consequences for an organization. This is because security breaches with a firm's contracts often result in additional financial, legal, and brand issues. For instance, security risks may arise during agreements when confidential or contract information is shared with the wrong parties, accessed by unauthorized individuals, or lost or stolen. When managing commercial contracts, security risks exist by storing contracts in insecure locations, allowing everyone with contract access to have the same level of access to sensitive contract data, leaving confidential contract data unencrypted, and using email to communicate sensitive information. 4. Brand risk. Brand risk, also known as damage to business risk, is associated with hostile public and customer opinion, poor employee morale, and is part of the aftermath of financial, legal, and security issues. Mitigating brand risk is essential because bad news travels fast in today's hyper-connected digital world and can quickly impact a business brand reputation. This would undoubtedly affect the firm's financial performance. 5. Operational risks. Operational risk is the risk of loss resulting from inadequate or failed internal or outsourced processes, people, infrastructure and technology, or external events. Poor or perverse incentives, bad planning and demand management, ill-informed buying, deliberate contract manipulation, and miscommunication can all erode a contract's value. Contract operational risks can be reduced through an effective internal control environment. Challenges of contract risks and how to mitigate them. There are several challenges regarding commercial contracts through which contract risks arise. Let us consider 4 core challenges of contract risks. 1. Transparency issues. Lack of transparency is a significant challenge of contracts. This could be frustrating scope creep, revenue loss, contract clause errors, and increased costs. Errors are never deliberate, but deliberately eschew a system that promotes transparency and minimize mistakes. The errors then become burdens that cause unnecessary issues and disrupt business processes. Unfortunately, contract errors are difficult to enforce, challenging to fix, and can cancel a binding contract. 2. Compliance and contract risk. Compliance goes beyond adhering to legal rules. It is a core function of maintaining or increasing savings, establishing a good reputation, and ensuring a well-respected brand. Companies have the challenge of navigating regulations, requirements, rules, industry expectations and business process change. Organizations' internal and supplier contract risks should be evaluated, analyzed, and eliminated. Non-compliance can lead to costly fines or breaches of contract that can break trust and damage relationships. An easy way to do this is through the visibility factors mentioned above. Contracts should be appraised and approved by the necessary parties to maintain compliance. It is also essential to develop a strategy around being aware of changing regulations and how to comply going forward with these new rules. Analytics and technology can be engaged to assess and mitigate contract risk. Even with completely automated systems, laws and rules still change. It is, therefore, important for all teams involved in contract work to comply with current regulations to ensure that companies are working within the correct local and global rules. Establishing compliance ownership clarifies processes and ensures that all parties know their expectations. 3. Insufficient speed. Time to signature is an essential factor, especially for sales teams. Contract creation takes several weeks or months, and several professionals are involved in contract creation. Inefficiencies and slow operations can impact contract creation, negotiation, and approvals. Project timelines should not be missed because the contract process is not fast enough. One of the easiest ways to reduce this contract risk is a contract lifecycle management platform. Having contracts stored in one easily searchable location eliminates searching through old emails or file cabinets and folders. Maintaining a template library that all users can pull from removes the need to create a new document from scratch for similar use cases. Finally, making sure that everyone who needs to view the contract can do so quickly makes it. This would improve the contract effectiveness and ensure that employees are no longer tediously emailing back and forth for visibility and access rights. Visibility is a significant challenge in contract creation. Yet this goes beyond just actual contract creation. Having the proper visibility into a contract helps the entire life cycle. Companies that do not allow the appropriate access for those who need it often have severe challenges managing their contracts throughout the contract life cycle. It is easier for the legal team to find quickly, review, and approve an agreement when it is time for renewals. Visibility is vital for companies in every part of the contract life cycle, especially in high-growth business phases. 5. Process inefficiencies. Practical contract management involves being aware of and mitigating any contract risks that come with the process. Communication across a company and a well-planned, written strategy are necessary for an organization to reinforce efficient operations. Lack of consistency across a company's documents and procedures can lead to many contract risks, including unpredictable pricing, unnecessary expenditure, and compliance issues. Successful businesses often develop processes, lists and workflows to avoid inconsistencies. Furthermore, elements such as a template library and legal visibility are also helpful in stabilizing organizational processes. Financial limitations of aggravated risks. Contracts' aggravated risks refer to above-average consequences of contractual risks. Impacts of financial limitations of aggravated risks include inferior or substandard contract works, death, bodily injury, breach of security, breach of confidentiality, infringement of intellectual property, and data loss and inadequate data storage. Contract risk management. Risk management entails identifying, assessing, and controlling threats to an organization's capital and earnings. Contract risk management entails identifying, assessing, mitigating, transferring, monitoring, and reviewing contract risks. Hence, effective contract risk management means attempting to proactively manage contracts to ensure the success of the contract work. There are 5 steps involved in a contract risk management process, which are: 1. Identify contract risks. 2. Assess contract risks. 3. Mitigating contract risks. 4. Transfer contract risks. And 5. Monitor and review the contract risk management lifecycle. Step 1. Identification of contract risks. Before the organization can assess and mitigate contract management risks, it is necessary to identify the risk in the contract process and determine where it exists. To identify a contract risk, the following questions should be addressed. Which contracts have higher risk exposure? This might entail a critical examination of the agreement, financial terms, privacy requirements, the use of specific clauses, or additional data points. Are there parts of the contract management process that introduce risk? Are there specific regulatory compliance risks that the contract parties need to manage? Do the organization and the sector have any geographic regulatory compliance risks that must be managed as parties are located in different states, countries, or legal jurisdictions? Ideally, to find and document as many risk factors as possible, build a cross-functional team that includes representation from every department involved in the contract lifecycle, from procurement to information technology, not just the legal team. Stakeholders should also be involved in identifying contract risks. Step 2. Assessment of contract risks. After identifying contract risks, the risks must be assessed based on their frequency and severity to the company. The more complete the risk assessment, the more accurate the results. Consider two main factors, the risk probability and the risk consequence. What is the likelihood that this risk will occur, and if it does, what will the impact be? The company may also consider the third dimension, the time factor. How do the risk probability and consequence of a contract change over time? If the company has a contract with specific unfavorable terms, as time passes and milestones are met, the consequences of not meeting the economic period diminish. For instance, the result may be higher early in the agreement and then lower over time. The probability, however, may be moderate in the beginning and increase over time. Contract risks can be assessed using the 5 categories of contract risk discussed earlier, that is, financial, legal, security, brand, and operational risks, based on the following 5 yardsticks. 1. Low, moderate, high, extreme. 2. How likely. 3. How frequently. 4. Possible effects. And 5. Risk appetite and financing mechanism for unintended losses. Step 3. Mitigation of contract risks. Contract risks can be mitigated in several ways, including the use of encryption to protect contract data, eliminate missed milestones and obligations through notifications and alerts, control access with role-based security, use clause and template libraries to increase compliance, maintain control over contract execution, use automated workflows to enforce business processes, and fast-track approvals using e-signatures, and mitigate contract risks through contract management software. Let us discuss these 8 ways of mitigating contract risks. 1. Use encryption to protect contract data. Use encryption to protect the firm's contracts from unauthorized access risk. The contact information should be encrypted on the contract site and with the latest encryption standards during transit. Any data stored within the contract management system is addressed, and in transit is any data sent externally to or from users or applications. 2. Eliminate missed milestones and obligations using notifications and alerts. Missing conditions activated by reaching certain milestones or automatic contract renewals may have significant financial consequences. They are entirely avoidable with the correct contact management solution. The company can set up automated alerts and reminders linked to the contract data record to stay apprised of critical contract milestones. 3. Control access with role-based security. Control who has access to contract information with role-based permissions. This ensures that only the necessary employees can read or write certain documents or contract types. By preventing unauthorized users from accessing or editing the contract details, the company would mitigate the security risk of having confidential and proprietary information make its way into the wrong hands. 4. Use clause and template libraries to increase compliance. Non-compliance is a significant source of contract risks. One of the most common reasons businesses run into compliance issues is using the wrong language and terms in a contract. By creating a contract clause and template library, anyone creating contracts can rest assured that they are using the latest pre-approved language from the legal team and general counsel. This mitigates contract risk inherent in the language that has not been properly vetted. The template can be modified appropriately for different circumstances. 5. Maintain control over contract execution. If the company has multiple parties cross-checking the contract document, it is crucial to maintain contract version control throughout the negotiation process. The company must track users' changes and allow them to simultaneously review and edit documents directly in the contract management system. This way, the contract team will avoid duplicating, missing, or using inaccurate data from transferring documents front and back. This is necessary to easily track and manage contract amendments, addendums, and terminations. 6. Use automated workflows to enforce business processes. Every stage of a contract life cycle needs to have documented contract workflows based on business rules that anyone involved in the contract process must follow. This ensures compliance with the approved procedures and processes to mitigate the contract risks and secure necessary approvals. It also helps to provide evidence of contract compliance appropriately. Building and triggering workflows eliminates the need to manually track and facilitate each step in the contract lifecycle, creating a smoother approval process. 7. Use e-signatures to secure approvals. Electronic signatures get documents signed faster and are more secure than paper signatures. Legally binding, thanks to the e-Sign Act of 2002, e-signatures provide a digital record about who, when, and where a document is signed to ensure authentication and assist with audit trails. E-signatures prohibit tampering with contract approvals and the possibility of misplacing a hard copy of a contract. They improve the approver's experience by supporting mobility, as contracts documents can be signed anywhere electronically. 8. Mitigate contract risks through contract lifecycle management software. Contract risks can be mitigated by engaging suitable contract lifecycle management software. Contract management software refers to various computer programs, data and instructions that streamline and digitize how legal agreements are managed to make the contract process more efficient. Contract management software can create, negotiate, sign, renew and gather actionable data on legal contracts. It is designed to replace the manual management of physical contracts and help lawyers and the teams they enable to tackle large contract volumes. The use of contract lifecycle management software helps eliminate back and forth contract management across different systems and communicate in one single place. There are several contract management software. Contract management software can assist contract parties by simplifying the entire contract process, reducing risk, and increasing transparency. A good contract lifecycle management software will address the central issue of contract risk by engendering collaboration in the contract negotiation and management process. It will also improve communication between colleagues, external stakeholders, and third parties. Let us consider the standard features of contract management software. Features of contract management software. While features of contract management products vary, nearly all solutions support business owners throughout the contract's document lifecycle. Here are standard features of contract management software. 1. Custom or innovative fields. This enables organizations to choose from standard fields for contracts or add custom fields to gather specific details about the company's client. 2. Automated approval process. Enterprise-level software allows an organization to set up workflows to ensure that the document passes through the right people for approval without wasting time. 3. Automated alerts. Automated reminders keep everyone in the know throughout the process, from email notifications of contract changes to alerts for milestones. 4. Redlining. This is where all parties edit contracts while tracking any changes. This is also part of negotiations in the digital world as documents flow to and from parties with changes accepted or denied. 5. E-signature. Many contract lifecycle management software offers native e-signature tools integrated into the software. Other companies incorporate a third-party e-signature tool into their software. 6. OCR capabilities. This is a text or voice-based search function, allowing an organization to quickly find contracts, clauses, or client data in the system. 7. Audit trails. Contract lifecycle management software can track all versions, conversations, and edits to show a clear audit trail of the contract documentation. 8. Content repository. Forget printing and filing hundreds of contracts. Instead, a content library should contain contracts, templates, and in some cases, standard clauses. Step 4. Transfer contract risks. In addition to mitigation of contract risks, as discussed earlier in Step 3, the residual contract risks which can be transferred should be transferred to insurance companies and other third parties appropriately. At this stage, it is necessary to define clearly, and review how and in what ways risk transfer is suitable for each of the contract risks identified. The risk transfer stage is essential for contract risk management and negotiation. The essence of contract risks transfer is to identify transferable contract risk and how the loss can be adequately insured. There are three major ways of transferring contracts risk exposures: indemnification, liability limitation, and subrogation waiver. We shall discuss the three ways of transferring contracts risks later in this video under transfer of contract risks. Step 5. Monitor and review of the contract risk management lifecycle. The contract risk management framework should be monitored and reviewed regularly. The review begins with clarifying misunderstandings and defining terms to ensure effective contract implementation at every stage of the contract lifecycle. Monitoring and reviewing contract lifecycle risks are necessary to provide a clear, auditable trail of the negotiation process. The monitoring process will assist in developing working contract management to ensure the accuracy and clarity of all aspects of the contract. A good contract life cycle monitoring and review should address the following questions. Are rights and responsibilities clearly defined? Do you agree on the soundness of confidentiality terms? Are indemnity clauses clear and complete? Transfer of contract risks. The essence of contract risk transfer is to offset all responsibilities to limit liability and loss of revenue loss. Contracts should be structured to allocate responsibility for risk to the party that creates it, well positioned to mitigate resultant contract risks. There are three broad ways of transferring contracts risk exposures: indemnification, liability limitation, and subrogation waiver. Let us discuss the three ways of transferring contracts risk exposures. 1. Indemnification or hold harmless. An organization can negotiate harmless indemnity terms to protect the firm from legal consequences and ensure merit compensation. Hold harmless agreement protects a business against lawsuits by requiring the parties you are doing business to refrain from suing you under certain circumstances. An indemnification clause obligates a party, known as the indemnitor, to compensate the other party, known as the indemnity, for losses or damages, physical injury or monetary, caused by that other party. In its purest form, indemnity is intended to save a party from the legal consequences or the outlay of money for defense costs and damages, to shift responsibility, partially or wholly, for payment to the party who caused the damages. Indemnification clauses are often closely tied to representations or warranties, promises that specific things are a certain way. 2. Limitation of liability. Limitation of liability, sometimes referred to as a damages cap, seeks to limit the amount payable in damages on a breach, restrict the types of loss recoverable or the remedies available, or imposes a short time frame in which damages are recoverable. Liability terms guard an organization against risk, thereby limiting the firm's liability. It is common to base the cap on a percentage of the value of the contract. 3. Subrogation waivers. A subrogation waiver is an agreement between two parties whereby one party agrees to waive subrogation rights against another in the event of a loss. The waiver intends to prevent one party's insurer from pursuing subrogation against the other party. Insurance is the primary way of waiving subrogation rights in any loss. Subrogation occurs when an insurance company pays the insured and then sues the entity or person responsible for the failure to recover the amounts paid to their insured. Contract parties should ensure that their contractual waiver terms close any gaps in risk by increasing commercial insurance, adding riders, and naming third parties. Let us now proceed to discuss insurance policies that are relevant in managing contract risks. Contracts insurance policies. Several insurances are relevant in managing contract risks, including engineering insurances, goods in transit, professional indemnity insurance, and fidelity guarantee insurance. 1. Engineering insurance. Engineering insurance refers to the insurance that provides economic safeguard to the risks faced by the ongoing construction project, installation project, and machines and equipment in project operation. engineering insurances are specifically used to protect construction works, erection, and operation of machinery. There are several types of engineering insurance products, including contractor all-risk insurance, erection all-risks insurance, plant all-risks insurance, machinery breakdown insurance, deterioration of stock insurance, and electronic equipment insurance. 2. Contractors all-risks, CAR, insurance. Car insurance is property insurance by which any building or civil engineering project under construction is protected against accidents resulting in physical damage to or the destruction of works in progress, materials and other similar items brought to the site. This policy provides cover for those with an immediate material interest in a project. These are the principal, employer, the contractor and usually all subcontractors, often including suppliers of materials and equipment. 3. Erection all risks, EAR, insurance. Erection all risks insurance covers the installation and erection of plant, machinery and equipment. This cover is usually adequate from the inception of work or offloading materials on site until successful testing and commissioning of the machinery, equipment or plant. It provides similar cover like contractors all risk, CAR, insurance policy against unforeseen and sudden physical loss or damage from any cause other than those expressly excluded. The insurance also includes a third-party liability cover against legal liability for damages due to the performance of the contract. 4. Plant all risks insurance. Plant all risks insurance policy, otherwise referred to as machinery all risks insurance but excluding breakdown risks, covers plants and machinery against unforeseen physical loss or damage that may arise from perils that are not specifically excluded by the insurance policy. It covers fire and accidental damage to the insured plant, including theft and burglary. 5. Machinery breakdown insurance. Machinery breakdown insurance covers insured machinery against sudden and unforeseen physical loss or damage, necessitating its repair or replacement resulting from fortuitous working accidents. This policy covers the insured who own and use different plant machinery and mechanical equipment. This is a policy designed to insure policyholder against damage to the machinery, already fixed and in use, due to breakdown caused within the machine. This policy covers all those who own and use different plant machinery and mechanical equipment. 6. Deterioration of stock insurance. Deterioration of stock insurance provides cover for loss of, or damage to, goods stored in any specified cold storage space due to deterioration or putrefaction arising from the breakdown of the refrigeration equipment or accidental damage. 7. Electronic equipment insurance. A computer, electronic equipment, insurance policy is designed for computers and peripherals, data carrying material and air conditioning plants, uninterrupted power systems and terminals. In this context, the term electronic equipment means all electrical and electronic systems such as electronic data processing, EDP, equipment, communication facilities, electrical equipment for medical use, and lighting and studio facilities. Electronic equipment insurance covers the cost to repair or replace specified electronic equipment following a breakdown. The insured can also decide to insure the additional costs to your business or business interruption and expenses caused by the electronic equipment breakdown. 8. Goods in transit, conveyance of items and materials. The goods in transit insurance policy covers loss of or damage to the goods insured caused by accident, theft, collision, fire, and overturning while in transit by road, air, rail and inland motorways. 9. Professional indemnity insurance. Professional indemnity insurance, often referred to as professional liability insurance, covers legal costs and expenses professionals incur in discharging their professional services to their clients. Many professions need to have professional indemnity insurance as part of their respective industry bodies' regulatory requirements. 10. Fidelity guarantee insurance. Fidelity guarantee is an indemnity policy that covers loss of property or money due to fraudulent acts by insured employees. Employers can purchase a fidelity guarantee insurance to cover the infidelity of employees who hold positions of trust like handling cash and stock. The policy is also referred to as staff honesty policy because it covers the dishonesty of an employer's staff. 11. Group personal accident insurance. Group personal accident insurance policy provides compensation for employees, by the employer, to protect them in an accident resulting in death, permanent disablement, total temporary disablement and medical expenses at the workplace. The policy should be purchased to cover employees engaged in the contract on the site and remotely. Group personal accident insurance policy serves as an incentive to boost the insured employees' morale. It further protects the company against the unplanned cost of staff medical expenses. Conclusion. The video has discussed contract risks and contract risk management. Contracts can be verbal or written and are used to create or expand the relationship between two or more parties. The most common type of contract is between two parties, with one acting as the supplier, provider or lessor and the other party as the purchaser, buyer or lessee. Therefore, contracting parties should consider themselves as the primary holder and financially responsible party for contractually assumed risk unless otherwise transferred via a written agreement. Contract risk entails potential losses due to a buyer's inability to pay or the terms of the agreement being broken. Risks associated with commercial contracts may be classified into 5 categories: financial, legal, security, brand, and operational risks. Contract risk management entails identifying, assessing, mitigating, transferring, monitoring, and reviewing contract risks. Contract risk management and mitigation is an essential part of business operations. Risk is present in commercial contracts, and appropriate contract risk management tools should be engaged in managing risks inherent in a firm's contracts. I hope the video is educative and beneficial to you. We love to hear from you. Kindly post your comments below in the comments section. If this video has been educative and beneficial to you, then give it a thumbs up and share it with your friends. Thank you for seeing the Risk Management of Everything videos. We love to hear from you. Please post your comments and questions in the comment section down below. If you are new here, make sure to subscribe to our channel, Risk Management of Everything channel, and press the notification button so you can be notified when we upload new videos. Thank you.